Well, when I first started, I was frankly very naive and uninformed. I basically followed the procedures and processes set forth by the people I learned from, Jerry Kane, John Stuart, and a whole bunch of other people. I just pretty much followed their procedure. And in the time that since the release of my book, I've become more educated, more sophisticated. And I still, I don't admit that I know everything, but I know more than I did when I first started the journey. And I've thus have amended significantly my process as outlined in my book initially. I've discovered a number of things that have made me very uncomfortable with the current administrative process. And I want to just go through my amended process in a nutshell with you, and I'll do the best I can to be as concise as possible. And before you see a list of documents that is in my kit that I want to kind of share with the people in my coaching program that is a more amended process to my original process. So in what we do is we send an initial letter out to the lender, and then upon their sending back of a bogus photocopy, we send them back a second letter disputing that they have any claim upon us and giving them one last chance to come in honor with us. And of course, they're not going to be able to do that, and they simply ignore us anyway. And so what we do is we pronounce their claim on us null and void through a notice of lender's default with a cover letter, and we send that out to the lender. And what we do is we basically give them 3 additional days, 72 hours, to contest our declaration. It's only fair. We want to be in honor. And so after 72 hours, it sticks. It's done. So they have officially gone into default. And what we do is we go into we then make a statement in an affidavit form declaring our actions to be exactly what we did, when we did, and what we said, and declaring that they have no claim upon us, and make that into the public record. So prior to this, all this process over here is what's called a private administrative process. This is just an exchange of papers between 2 private individuals. And what happens is when you have an affidavit of truth and then you record it in public record, this now transformed a private transaction into a public transaction. Now it's for the record. Now it's official. And in order to protect our credit, what we do is we have a credit dispute to let the credit bureaus know that this particular transaction is in contest, so that they don't go about destroying our credit rating. So that's what this letter is for. And what we do is after the affidavit, we file a civil petition against the bank, because now we've got actual proof and validated proof that they do not have any claim against us, and we want to have that blessed by the court system. So I've created this very elaborate petition here. Let me show you what it looks like. All right, so this is what the petition looks like. It's a verified petition for verification of debt, else release of claim. And you've seen this, but what you haven't seen is the updated form that I spent literally, oh my God, a lot of hours on. Right, so it tells the venue, gives judicial notice, provide causes of action, why we're suing them, and we want to verify that we are stating this for the record, with what claims that we want to bring before them, what evidence we're going to provide, and again, claim number 2. And look at this. In our evidence, we say the defendant has lost their right to contest this claim. We're making claims against the defendant, but they do not have a right to contest it, because they have basically they have lost their right through estoppel, through acquiescence. In other words, they've already been given an opportunity to contest the issue, and they have not come through. So we don't want to bring this up again. Their claim is done. So that's what the estoppel means. All right. And we've also entered an affidavit under penalty of perjury to attest to this fact in Exhibit D. See what I mean? Now we've got an affidavit unrebutted stands as truth and evidence before the court. So we've entered an affidavit in support of our claim. Okay. So I put in 4 claims. All right. So the claim number 3 is the defendant that lacks standing as a creditor, and number 4 is the contract is void ab initio. In other words, it's void from the beginning. It's unenforceable because no consideration was entered by the bank, and they didn't disclose what they were doing with our promissory note, and thus making the instrument fraud. and also quote some case law from the Credit River decision. Anyway, so I've quoted this. So it's a lot stronger than before, and I have a conclusion and remedy. I'm asking for all monies returned with interest, etc. And I did a verification as well and a certificate. And then evidences, exhibits, etc. in this. So it's a quite elaborate bit of the document. Okay, what else do I have? Right, in that petition, I've included a summons, a request for admissions. So the request for admissions is really powerful. In this request for admissions, we basically have a set of questions that they either admit or deny, and we pretty much back them into a corner. You know, did they advertise the loan? In other words, we're going to make them admit to their guilt as far as committing fraud before us and the fact that they didn't loan us any money through these questions and answers. And if they deny, then that's our opportunity to discover more into the contest and then prove that they have actually committed fraud upon us, and thus sealing the case. In other words, what I'm hoping to do is, you can see it's quite a number of different questions. What we're doing is we're basically asking them to answer all these questions before we go to court. And my hope is, if upon seeing this, their counsel is going to say, you know what, these guys have gotten us on a lie, and if we answer this, we're not going to win. So let's just let them win. This is a really powerful document here, the request for admissions, and this is going to be included in my kit. All right. Then we have a motion to compel. Now we've asked them nicely through our private administrative process, and they refuse to produce. Now we're having a motion to compel, to ask the court to compel them to produce documents. Also, I've got, now this is from John Stuart. I've got a memo of bank fraud. It's a memo that we give the court judicial notice that they should consider in making their ruling in our favor. It's a memo. It's quite elaborate. It talks about the fraud that is perpetrated by the bank. It's huge. It's case laws that the bank should take notice on. Right? It's got analysis, and it has the Credit River decision. Whole bunch of stuff that we're going to include as notice as part of our serving. And if your sale is coming up like next week, I also have included in here the temporary restraining order and the order that will make it easy for the judge to just sign off and send the order to us. And then I have a checklist to tell you what you need to include in your civil procedures. So we've moved basically from this, and let me finish this. I've given you a template on how to make a irrevocable living trust. And if they decide to play dead puppy and not show up, then we have a legal notice of judgment, a default judgment that we file at the court. That's how we win our case. So this is what is included in the kit. As I was saying, in my previous process, I went very heavy in the administrative process, but since in my education, I found out that, you know, even if you transfer the title from your name to another entity, that does not stop the bank from doing a trustee sale. They'll just steamroll over you anyway. So in my discovery, I've decided that we have to follow and play the game according to the system, and that is through the judicial process. But if you look at our judicial process, here are some of the documents that we'll be submitting to the court. Compared to most people who are uninformed in this particular arena, they're only going in with a petition saying, hey, produce the note. We're going in with a lot more things, with admissions. We have all this stuff that will hopefully make our case so incredibly strong that the opposing counsel will just basically says, you know what, our chance of prevailing is just it's not even worth our time to even show up, and let's just walk away from this. And because if they do show up, this is going to be for public record. It's going to be another case law for the entire state to look at as precedent. So it's going to look really poorly on the bank. And that's what we're hoping to do, is that they basically see that the overwhelming amount of evidence against them, that it's just not worth their while to play. So anyway, I've included a whole bunch more things in my kit, and I hope this will must make this process a whole lot stronger than what I initially had in my initial process. And of course, I'm going to be personally making amends to my process as far as doing it myself, because I mean, I just worked, God, so many hours in the last week perfecting this method, and I wanted to share this with you in hopes that it will make you better prepared in your defense against bank fraud.